going to talk about the fundamental patent requirement that an invention is new. And in particular, although there are a number of provisions under 102 setting forth how a patent is new, we are going to be looking at 102a and b, which are the most common provisions that are often hurdles to a patent being new, or rather a patent application being new. And in particular, we're talking about 102A and B pre-AIA, sometimes called the Old Patent Act, referring to inventions for applications filed before March 2013, after which the law changed. Now, the first thing you may be wondering in terms of this is, what are we looking at? Well, we're basically looking at two things. One is whether the invention is totally new to the world, and the other is whether it is so-called statutorily barred. We will explain what both of these mean, but first let's talk about when and where the question of new under 102A and B would be evaluated. There's basically two forums. One is the Patent Office, and the other is in federal courts for patent litigation. So obviously, since there are no patent rights, unless a patent is granted, the Patent Office must evaluate whether applications satisfy all the requirements of patentability, including that it's new. So a patent can only issue if all of its claims establish that they are not barred by either 102 or 102B. Either one alone could be a problem. In contrast, in a litigation, a defendant could win and not be liable for infringement if the defendant can establish that the patent claims asserted are not valid because of either 102A or 102B. Now, you may be wondering, how do we evaluate if a patent claim is valid under 102A or B? Basically, you compare the invention versus a single prior art reference. Now, when we say the invention, we mean a single claim. So if a patent has 25 claims, you actually have to do the analysis 25 times and make sure that each of those 25 claims satisfies both 102A and 102B. Now, the other thing to remember is that when we do this analysis, we're only comparing a single claim to a single prior art reference. So prior art could be a patent application, article, and there's only a problem if you have all of the elements of the invention in one single prior art. If you have most of it, then the invention is still new. If that doesn't seem fair, you're thinking actually about the separate doctrine of obviousness. That's when the invention is new, but it's not really that much of a benefit to the public, so it's considered obvious. But that's a whole separate issue. So sticking to new under 102A and B, let's think about what each of these does. So 102A is talking about anticipation, A for anticipation. Basically, this is saying that even though someone thinks that they've invented something, they're not going to be awarded a patent if, in fact, someone else came up with the idea before. In other words, someone anticipated them. And we evaluate this based on the invention date. So before you invented, someone came up with it before, with a default date being the date you applied. You could theoretically establish an earlier date, but the default date is a date of invention. Whereas 102B is talking about a bar. So B for bar, and why would you be barred? Basically, if you waited too long to file your patent application after you've done something so that basically your invention is out in the public. What does that mean? Well, maybe you sold the invention. You sold, say, a new car which has the new motor that you've designed. Or maybe you did a presentation where you told the public exactly what your invention entails. So if the public is already benefiting from the invention, it would be unfair for you to later file a patent, say years later, and take it back from the public possession. So if this sounds a little too harsh, it actually isn't, because in the US there is a grace period of up to 1 year after the public disclosure, by which the inventor could still file the patent and not be denied. But these are the two separate policy goals that are established in 102A anticipation and 102B statutory bar.